Good morning, this is your Kelso Report for Wednesday, August 24th, and I'm your host, Clark Kelso. We begin today with an interesting decision involving pleading in a securities fraud case. Complaints alleging securities fraud under Section 10b and Rule 10b-5 face some high hurdles at the pleading stage. In addition to Federal Rule of Civil Procedure 9b, which requires that claims alleging fraud must, quote, state with particularity the circumstances constituting fraud, close quote, the Private Securities Litigation Reform Act of 1995 requires that a complaint, quote, shall specify each statement alleged to have been misleading and the reason or reasons why the statement is misleading. And in addition, the 1995 Act requires that the complaint, quote, state with particularity facts giving rise to a strong inference that the defendant acted with the required state of mind, close quote. Well, in WPP Luxembourg Gamma 3 Sarl versus Spot Runner Inc., the Federal District Court had dismissed the plaintiff's amended complaint under Rule 12b-6 for failure to state a claim, mostly because the court concluded the complaint failed to satisfy the heightened pleading standards applicable to securities claims and failed adequately to allege loss causation. The Ninth Circuit panel unanimously reversed, concluding that with respect to most of the defendants, the complaint was adequate. The complaint essentially alleged a pump and dump scheme where the founding executives of a company called Spot Runner, which was suffering large operating losses unknown to investors, solicited the plaintiff, WPP, to buy shares in Spot Runner at the same time that the founding executives were selling their personally owned shares in Spot Runner. WPP alleged the founders did not disclose their stock sales despite contractual obligations requiring disclosure and despite WPP asking whether the executives were selling. The contractual obligation allegedly arose from agreements between WPP and Spot Runner, one of which gave WPP the right to receive notice if the founders intended to transfer any of their shares. The agreement included a provision allowing the rights in the agreement to be waived if 60% of the investors voted together, so long as written evidence of the waiver was provided to all the investors, including WPP. The founders actually did secure a vote of 60% of the investors to waive the notice provision, but that vote was not taken together with all of the investors. Instead, that vote was cast only by 60% of the investors who were favorably inclined to the founders, and WPP was never given notice that the waiver had been approved, contrary to the agreement. The Ninth Circuit held that these allegations adequately supported finding a duty to disclose. In addition, the founders' obvious efforts to keep their own sales secret from WPP, even at the risk of violating the obligations under the agreement, in order to try to keep WPP investing in the company, created the necessary strong inference of scienter required by the Private Securities Litigation Reform Act. As the Ninth Circuit explained, the founders' machinations to avoid giving notice of Spot Runner's poor performance and to avoid giving notice of the founders' share sales bespeaks a guilty knowledge, close quote. As for loss causation, the Ninth Circuit concluded it also was adequately alleged, since the complaint averred that when Spot Runner ultimately revealed that the founders had been secretly selling their shares while still encouraging outside investment, the shares WPP owned in Spot Runner immediately became worthless. In short, no investor would be willing to purchase shares after the founders' alleged pump and dump scheme became public knowledge. One last note about this case. The complaint also alleged a fraudulent scheme in violation of Rule 10b-5, which is a slightly different claim than a Rule 10b-5 omissions or misrepresentation claim. However, the complaint did not allege any additional facts in support of the fraudulent scheme claim. Following the lead of other circuits, the Ninth Circuit held that a defendant may only be liable as part of a fraudulent scheme based upon misrepresentations and omissions when the scheme also encompasses conduct beyond the misrepresentations or omissions. Not finding any allegations in the complaint of additional conduct, the court dismissed that claim. But the bottom line here is that the plaintiff gets to move forward to the next stage of litigation with its basic securities fraud claims intact. Now for our one-liners. First, a case involving probation conditions. In People versus Barajas, the 6th District rejected a vagueness challenge to a probation condition, prohibiting the defendant from visiting or remaining, quote, in any specific location which you know to be, or which the probation officer informs you to be, an area of criminal street gang-related activity, close quote. The condition was based on language previously approved by several courts of appeal, and it avoids vagueness by having a knowledge requirement, so that the condition is violated only when the defendant knows an area is a center for gang-related activity. The court also reviewed a probation condition that the defendant, quote, not be adjacent to any school campus during school hours, unless you're enrolled in or with prior permission of the school administrator or probation officer, close quote. Because of concerns that the word adjacent was too flexible a concept, the court modified this condition to read, you're not to knowingly be on or within 50 feet of any school campus, and so on. Although the court acknowledged that this modification was not perfect, it provided adequate guidance to the defendant about what conduct was prohibited. Next we have an ERISA case. In Withrow versus Bache Hayes Housley Stewart Shield, Inc., the Ninth Circuit faced the thorny issue of deciding when an ERISA action accrues for purposes of applying a statute of limitation. Because ERISA has no limitation period of its own, the Ninth Circuit borrows California's 4-year contract limitations period. But federal law still determines when an ERISA action accrues, and according to the Ninth Circuit, that happens either at the time benefits are actually denied, or when the insured has reason to know that the claim has been denied. The plaintiff in this case first contacted the plan in 1990, expressing concerns about the way her disability benefits were being calculated. What followed was a 14-year journey through customer service, and it was not until 2004 that someone from the company left a message for the plaintiff's attorney indicating that the company was upholding its denial of her claim. Not all 14 years was the company's. She had quite a few years where she didn't contact them. Nevertheless, she ultimately filed suit a little over 2 years after being told that her claim had been denied, well within the 4-year limitations period. The district court held that her claim actually had accrued and that she knew she had a claim back in 1990. The Ninth Circuit disagreed with this analysis, noting that the company kept encouraging the plaintiff to supply more information to substantiate her claim of miscalculation. And it was not until 2004 that the company actually indicated her claim was denied. The case was remanded for further proceedings. So, 21 years after raising her concerns and 5 years after filing her action in federal court, she is still waiting for a final determination of her ERISA disability claim. I would say that something is really wrong here. Next, we have a case involving the doctrine of preclusion, res judicata. In Merritt versus Ditto, the 1st District held that res judicata did not bar litigation of a claim for financial elder abuse when a prior judgment and appeal resolved the question of whether one of the defendants is an omitted spouse entitled to receive a share of the decedent's estate. The issue of financial elder abuse would not properly have been before the court in resolving the omitted spouse question. So, this appellate court held that the primary right at issue in the elder abuse petition was different from the primary right at issue in the original trial, and therefore res judicata did not apply. Next we have an insurance case, insurance coverage. In Aurora Marketing versus Hartford Insurance, the 2nd District held that an insurance policy exclusion for, quote, any violation of any intellectual property right, such as copyright, patent, trademark, trade name, trade secret, service mark, or other designation of origin or authenticity, close quote, that exclusion encompassed a claim for misappropriation of name or likeness. When a model sued the plaintiff, the defendant, because the defendant used the model's picture to market their products without her prior authorization. Although the court agreed that misappropriation of name or picture is a species of the law of privacy, it was one of the original 4 forms of privacy which Dean Prosser had recognized, and that the insurance policy generally covered claims for breach of privacy, the exclusionary clause in the policy was clearly triggered, because misappropriation of name or likeness was also a type of intellectual property claim. Finally, a remedies question. In Hill v. San Jose Family Housing Partners, LLC, the 6th District ordered a new trial be granted because of newly discovered evidence in a case involving a dispute between neighbors over an easement that granted the plaintiff the right to place a commercial billboard on the defendant's property so that it was visible to passing traffic. The defendant, who was the successor in interest to the property owner who entered into the easement, wanted to construct a multi-unit residential development on its property, but that development would obstruct the view of the billboard's north face. The plaintiff sued for injunctive relief to enforce the easement and for damages. The court ultimately awarded the plaintiff's damages in the amount of $778,000, which included lost future profits through the year 2037. Well, after trial, the city instituted administrative proceedings to require the plaintiff to take down the billboard on the ground that it had never been properly licensed some 40 years ago, and that it was therefore an illegal structure. Defendant's motion for new trial based on the city's efforts to remove the billboard was denied, but the 6th District reversed. It held that the city action, which was taken after the trial, was newly discovered evidence that the defendant could not reasonably have produced during the trial, and that it was material to the measure of damages, since, if the billboard was going to be removed, the award of future profits out to 2037 was improper. Now, to coordinate the new trial on damages with the city's efforts to remove the billboard, the 6th District directed the trial court to enter a stay of the proceedings, pending the resolution of proceedings between the city and the plaintiff regarding the removal of the billboard. That's a very creative solution by the 6th District. Although frankly, I think one does wonder whether the defendant, apparently a developer, exercised some type of influence over city officials, such that after the developer lost in court, the city suddenly became very interested in having the billboard removed. It may well be that the local trial court judge, who probably had a better appreciation of the local politics than the Court of Appeal, was trying to do the right thing by denying the motion for a new trial. After all politics is local, and none more so than land use development. And that's it for today's Kelso Report. Have a great day in the law.